Good morning, everyone. My name is Madhushri. Today I am going to present on my topic law relating to succession of property amongst Hindu. Let me start with the introductory part. The rights of a woman, the rights of a woman to succeed to any property vary from one religion to other, depending on the personal laws followed by them. The religion played a very important role in the evolution of a property of the woman in the earlier days. Law of succession was uncodified, but with the advent of modern governments and legislatures, most of the succession laws have been codified and consolidated. Hindu women and succession. The Hindu law of intestate succession has been codified in the form of the Hindu Succession Act 1956, which bases its rules succession on the basic Mitakshara principle. Prior to 1956, there used to be two major schools of Hindu law, Mitakshara and Dayabhaga, which laid down different principles of succession. Next, the position of a Hindu woman before 1956. Before 1956, the property of a Hindu woman was divided into two heads, mainly Stridhana as woman's estate. Stridhana literally means a woman's property. The Hindu law interpreted Stridhana as the properties received by a woman by the way of gift from relations. It includes movable and immovable properties. Stridhana as that what was given before the nuptial pyre, what was given at the bridal procession, what was given in token of love and received from a brother, a mother, or a father, it was considered as her absolute property. Next comes rights in respect of Stridhana. The Hindu woman had full rights of alienating the Stridhana, being its absolute owner. She could sell, gift, mortgage, lease, or exchange the same in any manner she liked. On her death, all types of Stridhana passed to her own heirs and not to the heirs of her husband. Thus, a Hindu woman had unlimited rights of enjoyment, alienation, and possession in respect of Stridhana as its absolute owner. The Supreme Court has explained the meaning and the nature of Stridhana in recent judgment. The properties gifted to her before the marriage, at the time of marriage, or at the time of giving farewell, or thereafter her Stridhan properties. It is her absolute property with all rights to dispose at her own pleasure. Husband may use it during the time of his distress, but unless he has a moral obligation to restore the same or it's the value of his wife. The Stridhan property does not become a joint property of a wife and the husband has no title or independent dominion over the property. Then the parliament has enacted Hindu Succession Act in the 1956. The 1956, this act was to amend and codify the law relating to intestate succession among Hindus. This act is applicable to all Hindus, Buddhists, Jain, and Sikhs by religion. According to section 14 of this act, property in this context includes both movable and immovable property acquired by a female Hindu by inheritance or device or at a partition or in a lieu of maintenance or by a gift from any person before or after her marriage. According to section 14, the property of a female Hindu to her absolute property. Any property possessed by a female Hindu, whether acquired before or after the commencement of this act, shall be held by her as a full owner and not as a limited owner. When the Hindu Succession Act was when the Hindu Succession was came into force, the change was made of her absolute property. Then comes retrospective effect. Section 14 is the retrospective insofar as it enlarges Hindu women's limited estate into an absolute estate, even with regard to property inherited or held by her as a limited owner at the time when the act came into force. In case of Dheeraj Kumar versus Lakan Singh, it was held that even if she alienates the property and is not in a possession at the commencement, she is the full owner as she was at the one time possessed of the property. But the Madras High Court in Marudakkal versus Arumugam and the Calcutta High Court in Ghosta Berry versus Haridas Samanta held that there is only prospective as the words shall be held and cannot be constructed as shall be deemed to have been held, and the expression whether acquired before or after commencement of this act applies to the word property and not to the word possessed. Next, I'll move on to discrimination in succession to dwelling houses. Section 23 makes a special provision respecting to dwelling houses. The object of the section seems to be prevent fragmentation or disintegration of a family dwelling house at the time of instance of a female heir, to the prejudice of the male heirs. If a female Hindu inherits a dwelling house along with the male heirs, she has no right to claim partition of a such house until the male heirs divide their respective shares. However, a female heir not being an unmarried daughter is entitled to reside in the dwelling house. A deserted wife or a female separated from her husband or a widow are entitled to right to residence in the dwelling house. A share in a dwelling house cannot be claimed by a married daughter. Next, the impact of remarriage of a widow on her right to succession. Section 24 lays down a disqualification for succession against the widow of a predeceased son, widow of a predeceased son of a predeceased son, the widow of a brother of a Hindu estate, intestate, if such widow has married when the succession opens. The remarriage, if takes place after the opening of the succession, does not divest such females of the property. The disqualification is confined to only three classes of widows mentioned before, and not to the other widows. In other words, once the succession is open, a widow cannot be executed from succession, even if she marries again. In Velamuri Venkata Shiva Prasad versus Koturi Venkateswaralu, the Supreme Court held that the Section 2 of the Hindu Widows Remarriage Act 1856 for the seizure of widows' rights is deceased husband property remain effective and would be applicable even in case of a void marriage. The court further held that the same remained effective after the enactment of the Hindu Succession Act 1956. Next, the Kopassanari rights. Kopassanari means that the part of a joint Hindu family which consists of persons who by virtue of relationship have the right to enjoy and hold the joint property to debts and their pleasure to enforce in partition of a female. A female Hindu was not considered as a Kopassanar, thus she could not enjoy the right of survivorship. She had only certain inferior rights such as of maintenance. Since she was not a Kopassanar, she was not entitled to act and as the manager or a karta of a joint Hindu family. The Hindu Women's Right to Property Act 1937 makes a serious inroad upon the rule of survivorship by making the wives of Koparsanar entitled to the interest of male Koparsanar in Mitakshara family on their death. However, under the provisions of this act, the male issue of the deceased Koparsanar remained Koparsanar along with the other surviving Koparsanar. The Hindu Succession Act 156 did not disturb this principle and still retained the same concept of Mitakshara Koparsanari. Next, the impact of Central Amendment to the Hindu Succession Act 1956 in 2005. A very important amendment has been made to the Hindu Succession Act 1956 in the year 2005. The object of this amendment is to remove the discrimination as contained in the Section 6 of the Hindu Succession Act 1956 by giving equal rights to daughter in the Hindu succession Mitakshara Koparsanari property as the sons have. This issue is inequality has been partially addressed by certain states, Karnataka and Maharashtra, by making state amendments. However, that was no amendment by the Act by the Parliament on this count. The Law Commission of India also made certain proposals on this issue in its report on reformer under the Hindu law. This amendment to the Principal Act has introduced many important changes in Act compared to the state amendment. After the enactment of this Act, there arose a problem enforcement of the amendment. The Supreme Court tried to solve the problem in three different cases as follow. The first case was Prakash versus Pulavati in the year 2016, in which the court opined that fathers should have to be alive on the date when the act was enforced. Thus, the daughters were only able to claim the benefit if the father died after the enforcement of the act. After this judgment, in the year 2018, in the case of namely Danama versus Amar Singh, the court held that if the father may have died before 2005, then also the daughter can be benefited. From this amendment, this judgment caused a lot of chaos between both cases were decided by two judges bench and created a lot of confusion. So finally, in the year 2020, in the landmark judgment in the case of Vinita Sharma versus Rakesh Sharma, the court held that father need not to be alive till 2005. The daughter has the coparcenary right since birth and hence can be entitled to the property of the father who may be alive or not. I could conclude by saying the position of a Hindu woman in respect of her property right has undergone unprecedented transformation from ancient times to the Hindu Succession Amendment Act 2005. The journey from exclusion to recognition of a Hindu daughters in Mittakshara Koparsaneri has been remarkable, but non-inclusion of other Hindu females are still denied there is irrational and unjustified. For all women are equally entitled to economic and social justice, which the Constitution of India proclaims. In spite of some progress brought by the Hindu Succession Amendment Act 2005, females are still denied their lawful rights in a predominant patriarchal society. Silence and self-denial on the part of a woman on being subjugated to unequal property rights. Women should be taken up to telling, bring about change in a mindset for promoting equal rights based on humanity for achieving gender equality. Thank you.